So, do you remember that so-called gamers lawsuit that was going around not that long ago? Well, it's been thrown out. Let's talk about what happened and what the judge had to say about the case and why it did not hold water. The one downside of all these cases getting thrown out is that we're not going to get all those juicy details I was excited about, especially in Northern California, where apparently they're more likely to do that sort of thing. But let me just bring up the website here really quick. The gamers lawsuit against Microsoft has been dismissed. And this whole article over on gamesradar.com basically links to Florian Mueller, who we had on the show. Thank you again, Florian. And it says, judge dismisses so-called gamers lawsuit. The complaint does not plausibly allege the merger creates a reasonable probability of anti-competitive effects in any relevant market. So they failed to make a compelling argument to the judge as to why it would cause a problem, especially because they're working with all these other agencies and they don't even know what the deal is actually going to end up being at the end of the day. They do have 20 days to respond. Now, I actually downloaded it and I read through the document. So let's take a look at some of the things that I highlighted here really quick. After carefully considering the complaint, the party's submission, and having the benefit of oral argument on March 16th, the court grants the motion with leave to amend. The complaint does not plausibly allege the merger creates a reasonable probability of anti-competitive effects in any market. So they talk about the case. The court accordingly scheduled the motion for a preliminary injunction to be heard on April 13, 2023, and directed Microsoft to produce certain discovery. In the meantime, Microsoft moved to dismiss the complaint on ripeness and standing grounds and for failure to state a claim. The court heard oral argument on March 16th, 2023. So this just happened last week. Section 7 of the Clayton Act generally prohibits business acquisitions whose effect may be substantially to lessen competition or tend to create a monopoly in any relevant market. Basically, what the people bringing the lawsuit failed to do was create an argument that showed that there would actually be a negative effect. The Supreme Court held the case was not right because there was so much uncertainty about whether such a policy would ever be enacted. They're referencing to something they talked about earlier. But here, in contrast, a merger agreement has been executed, and Microsoft does not dispute the merger could occur anytime on or after May 22nd, 2023, and only not until then because Microsoft stipulated not to merge before then. That the contours of the contract for merger may later change does not mean plaintiff's challenge is not currently ripe. So they're saying just because things are going to change, actually, they're refuting what I just said. Just because it may change, it doesn't mean that the person suing Microsoft didn't have a case. But at the end of the day, they dismissed it, so I guess they didn't make compelling arguments. First, Microsoft argues the named plaintiffs have not sufficiently alleged standing because the merger has not closed and is pending regulatory approval. It thus contends plaintiffs cannot show the necessary threat of injury that is certainly impending. So that was one of their arguments. I'm not sure what the conclusion was there. And then down here they said, to the extent plaintiff's claim is premised on reduced competition in the labor market, it is dismissed without prejudice for lack of standing. There's no evidence to back them up, basically. There's no reasonable evidence to back them up. So that was the finding on a lot of these points. And unfortunately, the gamers case ended up being dismissed. Here it is down here a little bit more about why. To meet its prima facie burden, a plaintiff must allege facts that plausibly show it is reasonably probable a merger will be anti-competitive. In practical terms, this means adequately alleging facts that an acquisition creates an appreciable danger or reasonable probability of anti-competitive effects in the relevant market. To meet its prima facie burden, the plaintiff must establish that the merger will probably lead to anti-competitive effects in that market. Merely alleging the elimination of a rival does not plausibly support an inference of an appreciable danger of anti-competitive effect in a relevant market. So just because Sony might be eliminated in the future, it's not enough evidence to back up your case. Simply put, there is no support for the notion that merely by removing one competitor and any horizontal merger in the airline industry will be anti-competitive and thereby violate Section 7. So even if Sony were to be eliminated, there's nothing to say that would be anti-competitive because there are still other entrants in the market. Jumping to the conclusion here real quick, the complaint's allegations are consistent with plaintiffs' theory that to satisfy their prima facie burden, they need only plausibly plead a reasonable probability that the merger will eliminate a Microsoft rival. For the reason explained above, the court disagrees. Microsoft's motion to dismiss is granted with 20 days leave to amend. To extend plaintiff's Section 7 claim is premised on a reduction in competition in the labor market. It is dismissed without prejudice for lack of standing. The preliminary injunction hearing is vacated in light of this order. The court will hold a status conference in person April 12, 2023 at 1:30 p.m. in courtroom 8, 19th floor, 450 Golden Gate Avenue, San Francisco. Floor 450, courtroom. Anyway, an updated joint case management conference statement is due April 7th. So we'll probably hear a little bit more about it on April 7th. But basically, Jacqueline Scott Corley, the United States District Judge, just said there's just not enough evidence here to move forward with the case. So they granted Microsoft's option to dismiss. Now, the only reason I'm a little bit bummed about that is because I wanted to see all the juicy details that the gamers were going to get. Separately, I felt like the gamers case actually made some interesting points about how this could affect the labor market, and it made me think a little bit more. You can check out that video. I'll link, that'll be the one that I link to for this video at the end. So it's interesting that this one didn't go through. You know, yesterday, I know I'm behind, but yesterday we talked about how the CMA response that Microsoft put together is going through right now, and the CMA is going to be looking at that. It'll be interesting to see what happens there. But yeah, gamers case is done. We'll see if they respond in 20 days. This was a class action suit, so I'm not sure that much is going to happen from this point, but time will tell. And, you know, very quickly, this whole thing could be wrapped up around April, and we could be hearing that either Microsoft is officially acquiring Activision and what that will look like in the future, and potentially some more side cases like this one. But that is an update. It's done. So it is what it is. Thanks for watching, everybody. If you like my content, hit that subscribe button, hit that button. If you're already subscribed, hit that like button, because apparently hitting the like button helps your video go around more. So instead of begging for subs, as so many of you say in the comments, I'm just reminding people to subscribe. Like, if you don't subscribe, okay, that's fine. You might miss out, but if you are subscribed, you want to do something, you can click that like button, and it does actually help channels. So thank you so much. Thank you to the members for supporting this channel. I really do appreciate you. If you don't like the ads, become a member at any level, and I turn off the ads for you. You can do that by clicking the join button. It's right down there. And like I said, I will link to my original thoughts about the gamers lawsuit, because I actually thought they had some interesting points in their original case that made a better argument than Sony did for the Call of Duty exclusivity part. Check that out right here. I'm going to get out of here, and I'll see you for the next one. Bye for now, everybody.